Hey everybody, it's Natalie Alicia Goldberg with the Gold Standard, and I'm here with my friend Amira Hasenbush. How are you, Amira?
I'm well. How are you?
I'm well. I think I totally mutilated your last name.
Sorry, everybody does.
So Amira is a family formation attorney. She focuses on adoption, surrogacy, sperm donation, and egg donation. She primarily drafts agreements and represents clients in parentage judgments and step-parent, second-parent, adult, and independent adoptions. She also represents litigants in complex disputes over parentage, as well as the use and ownership of eggs, sperms, and embryos. She's an active member of the National LGBT Bar Association's Family Law Institute, the Assisted Reproductive Technology Subcommittee of the American Bar Association, and the Society for Ethics in Egg Donation and Surrogacy. So, Amira, you are doing literally the cutting edge in law.
Yeah, I mean, I'm a fan of it. That's part of what I love about my work is it's always changing. There are always ethical questions. The science is changing. The law is changing. You don't get to just kind of put your feet up and relax and do the same thing every day.
So when people are coming to you, what does your typical client look like and how are you able to help them?
Yeah, well, I would say generally two types of clients are sort of my general typical client. So the first is an LGBT family who either already had kids or wants to have kids, and I'm protecting their rights as legal parents, or I'm helping them to sort of go through the whole process of building a family, or a family, whether LGBT or not, who is dealing with infertility and is trying to have kids in the less old-fashioned way. And so we'll look into adoption or surrogacy or sperm donation and kind of help them through that whole process from start to finish, make sure that they're legally protected and that they can, go on and raise a family like everybody else gets to.
So, Amira, you deal with literally such emotional stuff. On the one hand, it's a same-sex couple who could not have children in the traditional way. And on the other hand, it's a couple who could be same-sex or not and who's tried and has not been successful. And the level of truly, pain, judgment, all these things that people do upon themselves is at the highest level. So how do you kind of diffuse that energy when people come into your practice to tell them it's going to be okay?
Yeah, I mean, well, first of all, you can't make promises in this world, right? I mean, that's one of the first things that everybody who comes to me knows is that they've come from a place where it was supposed to happen this way and it didn't, right? And so I can't make promises, but what I can tell them is that there's a lot of stuff that's up in the air. There's a lot of stuff that I can't make promises on, but I can make the legal side the easy part, right? I want this to be the part that they don't really have to think very much about, that we deal with it and then they move on, because courts and documents and all that stuff can be very intimidating and very overwhelming. And the point is that I do the hard work so that they don't have to, so that it becomes much simpler.
Tell us about, I know when we spoke in advance of this call, it was truly, you were telling me about cases and I was floored that this could even be the law, and it is. So tell us a little bit about like how different family dynamics and kind of your craziest case so that we can know what actually is the law out there.
Oh man, my crazy. A lot of my kids, I tend to get the really complicated ones. They for some reason gravitate towards me. I like thinking, so I like the ones that are more complicated. So I've had cases. I've had a handful of 3-parent cases. In California, you can actually have a finding of more than 2 parents if you find that it would be detrimental to the child to have fewer than 2 parents. So I've had cases where there's a sperm donor who may or may not have intended to also be a parent. I've had cases where I've had couples who, I think I was telling you about the lesbian couple who was married but separated, still living together and raising their child together, probably for insurance reasons. Unfortunately, we don't have universal health insurance, so people get married and stay married and get divorced for all kinds of reasons. But one of the wives had eventually, met a new girlfriend and had a new relationship and wanted to have a baby with her new girlfriend. And so the problem is that there are parental presumptions based upon a marriage. And so even though the wives were separated, they were still living together, and the law presumes that a child born within a marriage is the child of both of the women. And so we had to write sort of a parentage, non-parentage agreement that said, girlfriend and wife number one are going to be the parents, wife number two is not going to be a parent. And then we had to get a judgment of that. And to make things more complicated, of course, girlfriend doesn't live in the United States. And so we have to deal with health insurance and international issues and all sorts of crossover issues. So I actually just had one this weekend. I didn't tell you about this because it literally just happened over the weekend. I have these clients, they are just the most wonderful, loving couple, a gay couple from China. So in China, you can't even get married, right? Let alone have a child through surrogacy. So a lot of Chinese gay couples will come to the US and work with surrogates here. So they had a surrogate who was due October 1st. It is not October 1st yet, as you might know. And because they're coming from China, they had to go to Dubai. They spent 14 days quarantining in Dubai. They got to the airport here on Friday night and got separated from each other, got held in separate rooms for 4 hours, just trying to get in, even though they had visas to enter and all this kind of stuff. They finally got through and the baby was born Saturday morning. So, sometimes these things, they work out just the way they're supposed to. Even
just in the nick of time.
So we had all kinds of, now because of COVID, we have, temporary guardianships and powers of attorney and all kinds of things that we put in place just in case people can't get here. But luckily, those documents were about 12 hours, not necessary. If they had been just a little bit later, we would have been using all of those.
Wow. And so with a surrogate, traditionally the surrogate does not have any parental rights over the child. Is that correct?
That's correct.
Has it ever been a case where the surrogate just fell so much in love with that child that they have tried to petition the court for some level of parentage rights?
Yeah, so it's very, very rare. It does happen from time to time. And I think that the important thing is to note how rare that is, right? And usually those cases make the news. So people think that it's more common because they see it in the news, but it's extremely rare, and especially as surrogacy has become more advanced over the decades. Now there's tons of legal screening, psychological screening, medical screening, so that hopefully you are going into this with somebody who understands what they're taking on and understands that this is not their child, right? You can't get psychologically cleared to be a surrogate if you've never been pregnant before. And that makes sense, right? Nobody can know how they're going to feel throughout and after a pregnancy if they've never done it before. So, it's very, very rare, but there are a handful of states in the United States where surrogacy contracts are illegal.
I think New York is one of them. When I was in law school, that was the case. I learned that probably close to 10 years ago. So I don't know if that's changed.
The law just changed, I think it was in April.
You're kidding. Wow.
Effect yet. And it's very limited still. I think you have to be a New York resident. So there are some states where it's like, we support surrogacy. You want to come here and do it, great. And then there are other states that are sort of somewhere in between. So I think New York kind of took a middle ground. But Michigan, for example, will not enforce a surrogacy agreement at all. And so there was a very famous case of a woman who was not in Michigan, but she went to Michigan to give birth. So that way the intended parents would not be able to make a claim to the child because she would be considered the mother in Michigan.
Wow.
Yeah.
I mean, that is truly devastating, right? Because the parents who are the ones who are going to be the parents of the child have been wishing, praying, and doing everything to make this baby a reality.
Yeah, well, and as rare as these cases are, I would say that they tend to run along a similar line, which is usually there is some finding by the doctor that the baby is going to have a very severe physical illness if the baby's born. And at that point, in the contracts, it will say, intended parents have the right to request that the surrogate terminate the pregnancy based on certain conditions, right? Sometimes that language is broad and the understandings are different between the parties. So it's really, really important that those conversations are had in a very serious and detailed way, because, what's serious to one side might not be serious to the other. And so these cases tend to run along the lines of the intended parents feel that it's very, very serious and is an appropriate time for a termination, and the surrogate disagrees. And so the surrogate will then, go somewhere else or try to, either take care of the child or adopt the child out to another family that's willing to take care of the child with very extreme special needs.
Wow. It's such a changing world, and truly, on both sides, beautiful to be able to give life in that way. And even from the surrogate's perspective, before you told me kind of the facts of how it generally goes down, I was like, what do they think? But hearing that, you're like, wow, what a beautiful heart and what a beautiful mission to give this child an opportunity to live.
Yeah, I mean, it's super complicated on both sides, and it's not easy. And our goal is to make sure that people are matched up. I've had surrogates come in who say, I will only terminate in the event of life-threatening. The baby can't live past a year kind of illness. And the intended parents come in and say, well, we're really not ready to raise a child with Down syndrome or spina bifida or something else very, very serious. That's not a match, and they kind of want to hope that it just won't come up. You can't move forward with people who just aren't a match. Both sides are acceptable decisions to make, but you have to make sure that they're the same on both sides.
Wow. I never even consider these kinds of things. And I'm a lawyer who kind of in the tangential area of practice is wills and trusts. So after the babies are here, how do we protect them, provide for them, etc. Amira, so you have with the surrogates, it seems to me either it's a same-sex couple that let's say the woman's egg is taken and implanted into the surrogate and then a sperm donor is used, or it's a couple that is heterosexual but cannot have children. So am I right to say that the egg and the sperm would be someone else's, or is the egg ever the surrogate's?
So it varies. It's pretty rare now. It's called traditional surrogacy, or now sometimes they're calling it genetic surrogacy, where the surrogate is also the egg donor, right? So it's her own egg. It's much less common than it used to be. It's generally not as well received under the law. So California has, so gestational surrogacy is the word for when the egg is not the surrogate's egg, right? Whether that's an egg donor who's a separate person, or if it's the intended mother's egg, it's not related to the surrogate. In California, we have a whole gestational surrogacy contract. It's very clear. Here's our contract and statute, excuse me. So it's very clear how you write your contracts, how you go through the process. There is not such a clear statute on traditional surrogacy. So those get a little more complicated. They do happen from time to time. I just took a case where it's a gay couple, and one of the husband's sisters is going to be their surrogate, and she's going to be the traditional surrogate, and that way they both get to have a genetic connection to the child. So obviously the one who is not the brother, the brother-in-law, is inseminating with his sperm, and they're using the sister's eggs and womb. So those are, it's still, you still have to go through all the screening. People think, oh, we all know each other, so it's going to be fine. But those can actually be more complicated because you don't feel as at ease to have the really hard conversations. And so I told them, I'll help you, but you need to get proper screening first and make sure you've gotten all the guidance you need from a therapist who specializes in this.
If a family is looking to go down this road, what can they expect as far as costs?
So it depends. It varies widely, but it is expensive. If you are working with a surrogate and you are using an egg donor, I would say if you, count surrogate fees, donor fees, legal, medical, all in, I would say typically you should expect somewhere between $100,000 and $200,000.
Mm-hmm.
Yeah. So it is not a cheap process.
No, it's not. And Amira, what you said earlier about we can have actually in California, for example, more than two parents.
Mm-hmm.
How does that come about? Because I know I was really surprised, and I'm a member of the California Bar to know that. So I'm sure a lot of our viewers are probably surprised to know that. And how do you, if you're not the parental who actually had the child, or was the father, who fathered that baby, how do you become that third parent?
Well, there are a lot of ways. Biologically, you can actually have three parents, right? So let's say you have a lesbian couple and their best friend is going to be their third parent with them. You can use the eggs from one. You can do IVF with the best friend's sperm, and then the other woman can carry the child, right? And you have three biological parents,
Wow.
which, modern medicine at its finest. It's really incredible. But there are so many different ways that it can happen. And sometimes they're more traditional than you might think, right? So you might have a standard different sex couple, husband and wife, that have a child together and they split up, and now there's a new girlfriend or boyfriend with one of the ex-spouses, and that person's also raising the child. Now they can ask to do a step parent adoption where the new girlfriend or boyfriend gets to be the second parent, but typically that will terminate the rights of the other spouse. But people might not want that, right? We have blended families where you really do want to recognize that the step parent has become a parent to the child, and California will now allow a step parent adoption that doesn't terminate anyone else's parental rights, and the child just gets to have a third legal parent. So, there are sort of non-traditional and traditional, and they're all different ways that people can become through a third parent.
So let's say the step parent adoption was not undertaken, but that step parent has been one very involved with the child's raising. Truly, they each feel, the step parent feels with the child feels with the step parent, that is their father, their mother, like their second father, mother, and not to displace, kind of the two founding partners. So if they don't go about a stepchild adoption, then is the only way to provide for that child through a will and a trust? I mean, how else would the state properly know that that stepchild and that step parent had such a bond?
Yeah, I mean, I guess it depends on what you're considering when you say provide for, but if you're talking about financially in the event of death, then yeah, absolutely, that's the way to do it. You could also set up guardianships if it's in the event of, God forbid, both parents pass away and that step parent should be the guardian, that's the other way to deal with it. But financially, yeah, it's through a will and a trust.
Yeah, a lot of people, I think, don't really think about that, about this has been the person who has felt like a parent for 20 years, 30 years, but a lot of people don't really consider, or maybe they consider, but it's hard to deal with, what happens if.
Right. And even when they get older, so let's say the second parent says, I'm not comfortable with you adopting my child. This is my kid. Not everybody is comfortable with it. There are many reasons why that can be reasonable. But the child turns 18 and says, you know what? I see you as my parent. I want you to adopt me. Once the child is 18, you don't need the parent's consent. The child can do an adult adoption with the person who they see as a parent, as long as the child has the consent of their spouse if the child's married, and the consent of the spouse of the person who's adopting. And they can either terminate their parental rights of the existing parents or keep them. That's their choice. But an adult adoption does not create inheritance rights. So it's the one type of adoption.
Really?
Yeah, where this is what my colleagues in that field tell me, is that it actually does not. And
I have never actually come across that issue, which is so interesting.
Adult adoptions are pretty rare.
Yeah.
So I tell people this is largely symbolic, right? It's beautiful, and I absolutely support it. It's a really beautiful way to appreciate somebody who's in your life, and it will matter for things like getting into the hospital to be with that person. I mean, in COVID, who knows? But under normal circumstances, right, there are certain people who are allowed into the hospital when somebody is in a really bad shape. So it would be useful for that, but otherwise it's really symbolic, because all of that inheritance stuff you still have to do through a will or a trust. They're not going to inherit intestate from you.
Wow. It's truly, so amazing to see the strides we've made and what is available to us as human beings that feel love, whether that's in a traditional form or not. And the law, especially in places like California, has tried its best to keep up.
Yeah, and it's always going to be a step behind science. Science is always going to go first.
If it's just one step, that's not bad. When it's 10, 15, 20 steps, then we're
Well, I do sit there sometimes, and I have a good connection with Equality California. So when an idea for a law comes up, I'll try to keep us only one step behind.
I love it. And Amira, what is your one big reason for being in this area of law?
My one big reason. Well, I was married to a trans man, so I understand this community in a way that probably a lot of people don't. And I've seen many people struggle with fertility, and it's just, to me, there is nothing more satisfying than like having a client send me a baby picture and be like, look what just happened. I mean, I just feel lucky to get to do my work every day.
It's beautiful. And I feel lucky that you joined us today to educate us on this very exciting, cutting edge area of the law. I know I've learned a lot, and I know my viewers certainly have. So thank you so much, Amira. It's, as always, a pleasure.
Thanks for having me.